Good morning, everyone. Thank you so much for being here for our presentation. Today, we have a great webinar called Presenting Your Medicaid Fair Hearing with Angela Jared Caldwell, who is one of our senior staff attorneys on our Community and Healthcare Services team. And throughout this presentation, we will be using a slide deck that is a variety of colors, but goes along with our Disability Rights Florida theme, which is this really nice orange and yellow and red theme with some purple tones throughout. My name is Maddie. I use she, her, they, them pronouns. I'm a white person with blonde and brown hair. I am the social media and content specialist with Disability Rights Florida, and I'm honored to help get this webinar started and introduce some of our accessibility considerations for today's webinar, including how to use Zoom and how you can, ask questions throughout the webinar, etc. So we can go ahead and go to the next slide. So you have a few options to access this webinar today for captions and ASL. First, for closed captioning, you can use the closed caption button, which is a button that says CC on it. And that's typically at the bottom of your screen. You have a little Zoom bar, a toolbar that has a bunch of different features on it, including the chat and reactions. So that's where you will find your closed caption button. Additionally, we have a external caption viewer that will provide the link to in the chat, and you can open in a different browser tab that closed captioning and follow along in a separate tab outside of Zoom. Finally, we have ASL interpreters, two wonderful ASL interpreters today who are spotlighted on your screen. And you should be able to access their video and see them at all times during the webinar, typically in the top right of your screen. Go to the next slide. Wonderful. Throughout this presentation, we really encourage you to ask questions and ask questions as we go through the presentation. You can submit questions using the Q&A button on the bottom of your screen. It's typically next to that closed caption button. Additionally, you can email us at webinar@Disability Rights Florida with questions if Zoom is less accessible for you or you're experiencing issues accessing the Q&A or chat features. Like I said, you can submit questions at any time and we're going to answer them throughout the webinar. This is a new topic for a lot of people and can sometimes be confusing. So we want to make sure we address any questions or concerns throughout the webinar and really make sure people understand. Finally, this webinar is going to be recorded and available on our YouTube channel and available on our website. We'll also be sharing those recording on our social media and make it available to the public. And lastly, we will provide these slides on our website after the closing of this webinar today. So if you want to go through and review these slides, if you had any questions, those will be available to you. So now I have the privilege of passing it over to Angela, who is our speaker for today, who is going to talk a little bit about who Disability Rights Florida is and give a brief overview of what we have going on in the webinar today through our agenda. Thanks so much.
Thanks, Maddie. Okay. So as a brief overview, just before I get started, I wanted to let everybody know that we're going to be doing a webinar series for pro se clients, and we're going to be covering discrete topics in each webinar. That's going to be going on once a month, I believe, from now until February is, I think we have one per month that is scheduled. So be sure to check our website for those upcoming webinars on the discrete topics. This is going to be more of an overview of kind of the whole Medicaid Fair Hearing process. But definitely, if you have some additional questions on discrete topics, feel free to email those over to us. They may guide some additional topics that we want to cover, and we surely appreciate all the feedback. So let me start out with a little bit about Disability Rights Florida. Disability Rights Florida gets our funding, responsibility, and authority under 9 federal programs to protect the rights of Floridians with disabilities. And we've been a not-for-profit corporation since 1987 in the state of Florida. We have offices in Tallahassee, Tampa, Gainesville, and Fort Lauderdale. However, many of our professionals, our advocates, our attorneys work remotely, and we cover the entire state of Florida. Our mission here at Disability Rights Florida is to advocate, educate, investigate, and litigate to protect and advance the rights, dignity, equal opportunities, self-determination, and choices for all people with disabilities. And here's a brief overview of the agenda that we're going to be talking about in today's webinar. So we're going to be talking about preparing for a fair hearing, the documentation and evidence submission that you may need to do in a fair hearing if you have a fair hearing pending, how to present your case as a pro se litigant, meaning that you're not represented by an attorney, the procedure for fair hearings and what to expect. And then I will be taking questions. And as Maddie said, if you have questions throughout the presentation, please go ahead and put those in the chat or put those in the Q&A so that I can answer those contemporaneously with what I'm talking about. I feel like that sometimes works a lot better and people get a lot more out of it if I'm able to answer those as we're talking about a certain slide or topic. So if you have something, please feel free to ask it at any time, and hopefully Maddie will stop me and we can go over questions as we go along. So let's go ahead and get started. Preparing for a fair hearing. Disability Rights Florida's Advocacy 101 is a manual designed to assist individuals in preparing for a Medicaid case before Florida Division of Administrative Hearings, DOA, D-O-A-H, the Florida Office of Fair Hearings, OFH, Agency for Healthcare Administration, the Florida Office of Appeal Hearings, OAH, Department of Children and Families. And you can find our Disability Rights Florida Advocacy 101 manual online at our website, disability_denial_Medicaid_SE. DOA offers Florida public agencies an impartial, efficient resource to hear and resolve internal and external disputes over government decisions, such as public employee discipline, disability retirement claims, construction standards and contract disputes, state and local code violations, public facility use and siting, conflicts of interest, bid disputes, and many others. OFH, the Florida Office of Fair Hearings, does fair hearings for Medicaid fee-for-service and managed care, MMA, and LTC waiver. Office of Appeal Hearings, OAH, is the office that handles APD, the Agency for Persons with Disability hearings. And those are hearings that involve the I-budget waiver. So specifically, the Office of Fair Hearings, OFH, is part of the Agency for Healthcare Administration, and OFH employs hearing officers who conduct hearings in cases affecting Medicaid fee-for-service and managed care recipients. The OFH website is available at https flmedicaidmanagedcare.com/home/Medicaid Fair Hearing. The Office of Fair Hearings, like I said, is part of the Agency for Healthcare Administration. OFH employs hearing officers who conduct hearings in cases affecting fee-for-service and managed care recipients, as well as LTC waiver claims. In fee-for-service cases, OFH has jurisdiction when the agency or its agent reduces, suspends, terminates, or denies a service. In managed care cases, the Office of Fair Hearings has jurisdiction when the managed care plan reduces, suspends, terminates, or denies a service, and the recipient has exhausted the plan's internal appeal process. In both types of cases, failure by the agency or the plan to adhere to notice and timing requirements may also give rise to the Office of Fair Hearings jurisdiction. The Office of Appeal Hearings, OAH, is part of the Florida Department of Children and Families Office of Inspector General. OAH employs full-time hearing officers who conduct hearings in cases where a state agency, such as the Agency for Persons with Disabilities, APD, or the Department of Children and Families, DCF, makes a decision which unfavorably affects a person's rights or benefits. And the Office of Appeal Hearings website can be found at https://about/office-inspector-general/appeal-hearings/. OAH, or the Office of Appeal Hearings, employs full-time hearing officers who conduct hearings in cases where a state agency, usually Agency for Persons with Disabilities or the Department of Children and Families, makes a decision which unfavorably affects a person's rights or benefits. And on this slide, I'm just sharing the Office of Fair Hearings contact information. So the Office of Fair Hearings contact information for requesting a Medicaid Fair Hearing from ACA is Agency for Healthcare Administration Medicaid Hearing Unit, P.O. Box 60127, Fort Myers, Florida 33906. You can also contact them via telephone at 877-254-1055 or fax at 239-338-2642. You can also send a request for a Medicaid Fair Hearing via email by emailing Medicaid Hearing Unit at aca.myflorida.com. The Office of Fair Hearings contact information for obtaining information from ACA regarding a Medicaid Fair Hearing request is the Agency for Healthcare Administration Office of Fair Hearings, and the address is 2727 Mahan Drive, MS number 11, mail stop number 11, Tallahassee, Florida 32308. You can also contact them for obtaining information from ACA regarding a Medicaid Fair Hearing at their telephone number at 850-412-3649 or via fax at 850-487-1423. You can also contact them via email at officeoffairhearings@aca.myflorida.com for any information regarding a Medicaid Fair Hearing request. The contact information for Office of Appeal Hearings is the Department of Children and Families, Office of Appeal Hearings. The address, is 1317 Winewood Boulevard, Building 5, Room 255, and that's in Tallahassee, Florida 32399. You can also contact them via phone at 850-488-1429. The fax number is 850-487-0662. Or you can contact them via email at appeal.hearing@myflfamilies.com. Okay, so now I'm going to go over some of the terms that you may hear if you request a Medicaid Fair Hearing. These are typical words that are going to come up. And so I wanted to give an overview of what these words are and what their definitions are so that everybody is on the same page if I should use these words a little later in the presentation. So the person requesting a Medicaid Fair Hearing is called the petitioner. The person requesting an appeal, the person whose services are being reduced or denied or terminated. The respondent is either the agency, so in the Office for Fair Hearings, that could be ACA. In the Office of Appeal Hearings, that could be APD. Or organization that has reduced or denied a petitioner's services. So that could also be a managed care plan. Exhibit is a piece or set of evidence in a hearing, usually a document. However, exhibits could be a variety of things, some of which I'll talk about here in a few minutes. The hearing officer. In both OFH and OAH hearings, there will be a presiding hearing officer, and this is simply a judge at your fair hearing. And the burden of proof. So the burden of proof is the responsibility of a specific party, either the petitioner or the respondent, to use the evidence to prove to the court and the hearing officer what the party believes the outcome should be. And it must be proven by a preponderance of the evidence, and that standard is more likely than not. So a few additional things that could be exhibits other than a document. It could be a picture. It could be, for example, in a Medicaid Fair Hearing, a prescription or a medical document. It could be really any number of things. But when we talk about this in a little bit, an exhibit is just a single piece of evidence, many of which that you will probably file in a Medicaid Fair Hearing. You will gather the evidence, you will want to file it as evidence so that the hearing officer and the other party can review it before the fair hearing. And you may ask questions about the exhibits in the fair hearing. And these are all just documents or evidence that help you prove your case. So notices. Whether it's a decision being made by ACA, APD, a managed care plan, or others, if it's an unfavorable decision, they must send you a written notice whenever they deny, reduce, or terminate your request for supports or services. Verbal notice is not enough. Do not accept verbal or other informal notice. If you don't receive written notice, request it as soon as possible. Look for 3 things in a notice. 1, you want to look at what is being denied or reduced. 2, you want to look what is the justification for the denial or the reduction. And 3, what are your appeal rights and what are the instructions that you need to follow? So for notices, you will also get notices when you are making your original request for eligibility with APD, and also when you are requesting crisis enrollment to the iBudget waiver. Both of those, both the eligibility request and crisis application process through APD, once you get a notice, you do have fair hearing rights. So requesting an appeal, this is slide 1 of 2 on requesting an appeal. So first, whenever you get a notice, you need to review it, like I said, and follow the instructions in the notice. The deadline for requesting an appeal varies depending on the agency, but it should be clearly stated on the notice that you receive. And those notices should be received in the mail at your current mailing address. So the most important thing to keep in mind when you receive your notice is that there are deadlines associated with this step. There are two deadlines that you may want to keep in mind. The first is that you have 30 days to request an appeal. And past 30 days from the receipt of your notice, if you wait that long before requesting an appeal, the agency is not necessarily required to allow you to enter the appeals process or to give you a fair hearing. So if you wait past 30 days from having received your appeal, you may not be able to argue for the services that were denied or reduced. You may have lost that right. So it's critically important that you keep a record of your timeline. Make sure things are done certainly within that 30 days, and considering this additional timeline as well, 10 days versus 30 days. So Medicaid requires an appeal within 10 days. And this used to be the standard with APD as well. APD's recent notices have stated within 30 days. So be sure to read your notice carefully to ensure you are within any time frame specified in the notice to request an appeal. The notice oftentimes will have a form attached to it, which will include blanks for information, which can be used to request the appeal. And it will guide you in supplying all the information you need to, and should contain the name and address of whom the form should be either mailed or faxed or sent to. So the person that is going to be representing the individual in a fair hearing. Sorry about that. So when you go through the notice and you get to that form, that's probably the simplest and most appropriate way of requesting a fair hearing. It will give you the address or the email address that we just went over previously, that you can submit that form to. And once you submit that form and it's received, there will be a fair hearing number assigned to your request, and you will get an acknowledgement of receiving that hearing request form. Once you receive the acknowledgement with the fair hearing file number, after that, you will receive a scheduling with additional instructions. And it's important to note that in Medicaid fair hearings, you don't necessarily have to have an attorney representing you in a fair hearing. You can represent yourself. You can have a qualified representative, such as your waiver support coordinator that represents you in a fair hearing. You can have an advocate represent you in a fair hearing. And for an attorney, you can contact Disability Rights Florida, the Florida Bar Lawyer Referral Services. You can seek a private attorney, or you can contact other legal aids or legal service organizations in your area. So requesting an appeal, and this is the second of 2 slides on requesting an appeal. Be sure to make it clear if you wish to continue to receive services pending the outcome of your appeal. So if you're requesting ongoing services and an agency reduces or terminates that service, you can continue to receive those services while the appeal is pending, but you do have to make it clear when you request the fair hearing that you are requesting the services to continue until the outcome of the fair hearing. The deadline for requesting to continue to receive services may be different than the deadline to request an appeal, and will be clearly stated on the notice you receive. Sometimes you must request continued services immediately following the adverse decision. Make a written request by email, fax, or mail for the appeal if possible, and save a dated copy of the request. Medicaid managed care plans and the Office of Fair Hearings utilize verbal requests for fair hearing. Write down the date, time, and name of the staff you speak with when you make a verbal request. And even if you make a verbal request, I would still suggest following up, probably via email would be the easiest way, with the email addresses that I sent you that we went over previously, just saying, I spoke with so-and-so on October 1st, 2024, and I requested a fair hearing because, for example, the Medicaid Managed Care Plan reduced my personal care service hours. That way you have it in writing and you can always go back to it if there should be a dispute about whether or not you requested a fair hearing timely. Maddie, is this a good time to go over some of the questions that are in the chat? Do we have any that are in the chat?
Hi, Angela. This is Maddie speaking. We had one question that I was able to clarify, but I'll repeat just so other folks can hear it. Someone asked, will handouts be available with all of this information? And just to re-clarify, we will have the slides for this presentation along with the recording of this webinar available on our website and YouTube channel. And we're also providing links to the various resources that Angela is mentioning throughout this webinar in our webinar chat. So you will be able to access all of those resources throughout the webinar, and yes, they will be available on our website after the fact. Other than that, there aren't any specific questions regarding the content at this time.
Okay, thank you, Maddie. Okay, so we're going to proceed on with the presentation. Next, we're going to talk about the key differences when requesting an appeal. And this is slide 1 of 2 on the key differences of when requesting an appeal. So there are 5 key differences in the appeals process for each agency and managed care company. When appealing a notice of adverse benefit determination from a Medicaid managed care company, managed Medicaid assistance, MMA, or long-term care waiver, LTC waiver, you must submit a plan appeal and receive a notice of plan appeal resolution before you can request a fair hearing, which is conducted by the Office of Fair Hearings, like we discussed earlier. So basically, this is to say, when you receive when you're appealing a notice of adverse benefit determination from a managed care company or the LTC waiver, you must exhaust an internal appeal process before you request a fair hearing. This is an opportunity in this case to for the agency or the managed care plan to look at the request again, look at the documentation again, and determine whether or not the correct decision was made at the notice of adverse benefit determination. So when they issue the notice of plan appeal resolution, they will either uphold the notice of adverse benefit determination that was made originally, or they may overturn it and approve additional services or hours up to the amount that was originally requested. But they can also look at it again and approve a portion of it, but not the whole amount that was requested. The key differences when requesting an appeal, and this is the second of 2 slides. When appealing a notice of outcome from EQ Health Solutions, you can request a reconsideration, but it's not mandatory. You can request a fair hearing without requesting a reconsideration. And the fair hearing is conducted, like I said, by the Office of Fair Hearing. When appealing a notice from the Agency for Persons with Disabilities, APD, there's no reconsideration or secondary review. The request for a fair hearing will be submitted to APD directly, and the fair hearing will be conducted by the Office of Appeal Hearings. So when you're appealing a notice from the Agency for Persons with Disabilities, you're going to, when you request, there's no internal appeal process like there is with ACA, the managed care companies, the LTC waiver. So when you get an adverse benefit determination from the Agency for Persons with Disability, you are going to be requesting a fair hearing directly.
Hey, Angela, this is Maddie. We have a couple questions from these two slides.
Okay.
First, someone asks, if I live local, do I go to a local court or do I go to a Tallahassee court?
I'm not sure what you mean by live local. However, the Office of Fair Hearings, so that's an ACA managed care LTC waiver case. Those are all conducted via phone. So you don't have to actually go anywhere. You call into a recorded line. So the petitioner, the respondent, any of the witnesses, and the hearing officer will all call in to a recorded line, and the entire hearing will happen over a recorded phone line. For Agency for Persons with Disabilities or Office of Appeal Hearings, you can request either an in-person or a telephonic recorded hearing. I would say the lion's share of those are still conducted via phone on a recorded line. However, if you choose to, you can request an in-person fair hearing. And they try to accommodate where a petitioner is located. However, that's not always the case. That's not always an available option, but they do try to make it they don't try to make it too difficult. If someone wants to request a hearing in person, they do try to make it possible that they can have it somewhere locally. So whether that be, I don't know if you live in Tallahassee or where you live, but it could happen throughout the state.
Okay, thank you. The same person wanted to clarify, what is the process for folks who are deaf? Is it a video call or is it in person?
So you can have a translator, you can have someone that's doing sign language that's a part of the conversation or a part of the fair hearing. For those, yes, you would have to request accommodations for the fair hearing, and I would suggest requesting those at least a week before the hearing is scheduled to be held.
Okay, great. We have two additional questions. Someone is requesting, if I'm understanding the question correctly, for key differences, the first of those two slides, can you go through that again? So the previous slide, then the one you're on right now, could you please go through that information again?
Sure. So basically on this slide, what I was trying to explain is that there's an internal appeal process for any decision that is made by a Medicaid managed care company or the long-term care waiver. So an individual receiving LTC waiver services. So in those circumstances, if you, for example, say you requested 50 hours of personal care services and you received a notice of adverse benefit determination denying 25 of the 50. You have to then submit an internal plan appeal. So it's basically a second look at the original request for services, and you're asking that the plan or the agency to take another look, take a look at the documentation that was submitted and the request for services, and you're asking them to again approve the original 50 hours in this example. So they will, the plan or the agency will look at it again, and they will issue a notice of plan appeal resolution. That's after the notice of adverse benefit determination. And that is the internal plan appeal process. So once they issue the notice of plan appeal resolution, they can, for example, they could approve the whole 50 hours that you originally requested. Or they could say, no, we're going to uphold the 25 that we felt were medically necessary with the notice of adverse benefit determination. Whatever determination they make at the notice of plan appeal resolution, when they issue that notice to you, that is when you have that is when you can request a fair hearing before the Office of Fair Hearings. It's just that you have to exhaust that internal plan appeal process before requesting a fair hearing in those circumstances.
Okay, thank you. We have some more questions coming in if you want to pause and take some more questions at this time. One is posing their current experience, but could be a good example for some folks. They are the grandparent of a child in the PPEC service in the state of Florida. And they decided to put their grandchild in PPEC for the first time, but they were denied by EQ. So how can they request a continuance of PPEC?
So if I'm a little confused. So if you were already approved for the PFEC services, and now they are denying it, or now they are no longer approving it going forward, then that's a situation where you can request that the services remain authorized through the fair hearing process. However, if they never received the PFEC services, that would be a new request for services. So they never received it. If they were then denied, then you're not entitled to receive ongoing services because they never actually received them.
Okay, thank you for that. Someone in the chat had a question. Could you have a doctor sit in on your fair hearing call to provide essential medical information?
Absolutely. Yes, we'll talk about we'll talk about the documentation and evidence here in some slides that we haven't talked about yet, but yes. So you will you'll want to determine who's essential to proving that these services or that the services that you requested are medically necessary. So you will want to have a doctor or an expert that's willing to testify at the fair hearing on the record.
Great. And then we'll answer one more question, and we can move on, and maybe some of this will continue to get resolved as we move forward. Someone writes, recently I received a letter from ACA for SMMC for my adult son with disabilities that is on CDC Plus that may be changed to SMMC in February of 2025. I thought that iBudget Medicaid waiver and CDC Plus waivers are two different waivers. My question is, would I submit a hearing with OFH for this change? And that's in the webinar chat if you'd like to read through it.
Okay, thanks. Yeah, I'm looking at it. So CDC Plus is not a waiver. CDC Plus is a program. So through CDC Plus, it gives you more flexibility in choosing providers to work with an individual with disabilities, as opposed to you can choose your providers, but you can't normally, like the managed care plans will be contracted with a list of, for example, home healthcare companies. So if you don't want to use one of the home healthcare companies that are on the list, you may choose to do CDC Plus in order to be able to choose who your provider is. It just gives you a little more flexibility, but it's not a waiver, it's a program. And if I'm not sure what you would be submitting a hearing request for. So if it's a regular Medicaid managed care, statewide Medicaid managed care, that he's receiving, then you would be requesting a fair hearing if the services changed through the Office of Fair Hearings. If it's iBudget waiver services, you would be requesting that are in dispute, then you would be requesting it through the Office of Appeal Hearings.
Thanks, Angie. I think we're gonna go ahead and move on for just to get through some more slides, and then we can pause for some more questions in a little bit.
Perfect. Okay, so we already went through this one. Okay, so documentation and evidence submission in a fair hearing. So we talked about this just a little bit previously, but you should get a scheduling order from either the Office of Fair Hearings or the Office of Appeal Hearings stating when and where the hearing will be held, along with directions for submitting evidence prior to the fair hearing. In order to determine what documentation and evidence you may want to submit to the hearing office to support your case, you'll need to research the laws and rules that affect your case or services, and speak with witnesses and gather additional evidence to support your position or arguments at the fair hearing. So we always suggest preparing early. All of the decisions that a hearing officer is going to make are going to be guided by laws, rules, and policies. So the law, rule, or policy should be listed in the denial notice, which that goes back to the 3 questions that we always look for in a notice. So you'll want to go back to your notice. You'll want to look at what's been denied or reduced or terminated and the reasoning it's been reduced. So if it's based on a statute, it should list the statute or list the Florida Administrative Code that they're using, that the agency or the managed care plan is using to deny, reduce, or terminate the service. Then you want to write out how the law, the rule, or the policy, after you've reviewed it, applies to your specific case and circumstances. So get the documentation and the support that you need to prove your case through gathering, if it's medical documentation, if it's talking to witnesses that could be providers such as nurses, home health care agencies, it could be therapies, it could be your doctor, it could be a specialist. You really want to take a look at what's been denied, what the reasoning is, and what you think you're going to need to put on as far as evidence and testimony at the fair hearing for the hearing officer to make a determination that's favorable for you. And then after you do all of that, you're going to organize how you will present your case and your information when you get to the fair hearing. And before every hearing, you should, in the notice, it'll give you, like I said, a timeline for submitting your evidence. I always suggest doing it at least a week ahead of time, but it should give you the exact number of days that you have that they want you to submit your evidence prior to the fair hearing. And that just allows the other side, the respondent, the agency, or the managed care plan to have time to review any of that information that they may not have already had. So any new or additional information that they didn't have. and prepare for the fair hearing. You should also receive before the fair hearing an evidence packet from the respondent. So if you're you're the petitioner, you're requesting a fair hearing because a service has been reduced, denied, or terminated, whatever information that the agency or the managed care plan used in making that adverse determination, they should have to file in the fair hearing as evidence, and you should receive a copy of that. Usually the notices say that they should file it within 10 days of the request for fair hearing, but certainly at least, a week to 10 days prior to the scheduled fair hearing, you should receive their information, whatever evidence that they're going to bring at the fair hearing. And that allows you also the same opportunity to prepare for your fair hearing, to know what evidence they have that they're going to make arguments on, and be able to possibly line up other testimony or other documents that you may need to counteract what the arguments are that the agency or the managed care plan may bring. So, evidence and witnesses. Evidence can include, we talked about a little bit of this earlier, medical records, school records, letters of medical necessity, letters of support from family, friends, professionals, providers, IEPs. It could really be evidence can really be anything. Pictures, it can be behavioral notes. It's imperative that you determine what evidence is going to be the most crucial, and that you make sure that it's filed into the fair hearing so that it can be reviewed by the hearing officer when he or she is making the final determination. And witnesses can be anyone with specific knowledge about the subject of the fair hearing, and they can include, like we discussed previously, your physician, a specialist, a provider, a case manager, a waiver support coordinator, family members, friends, anybody with specific knowledge about the issue of the fair hearing can testify. Prepare your testimony and talk to your witnesses about their testimony prior to the fair hearing. So before you go to the hearing, you're going to want to, when you're organizing who you think your witnesses are going to be and what questions you want to ask them so that you can elicit the testimony that is pertinent to getting a favorable decision, you're going to want to talk to those witnesses, and you're going to want to say, okay, if for example, you've been my nurse for 10 years. I want to ask you what a typical day in my life looks like. So you want to ask them that before you get to the fair hearing, so you know what they're going to say, right? And so that you also know that you can kind of talk through and make sure that the answers are complete answers. And this is really just more for preparation and knowing ahead of time what kind of information is going to be elicited, and the testimony that's going to be taken into account when the hearing officer makes their final decision. So you can also request additional information or documentation from the agency or the care plan through the process that's called discovery. And again, to engage in the discovery process in a Medicaid fair hearing, you do not have to be an attorney. So you can send questions to the agency about how they made, for example, how they made the determination. And that is called interrogatories, and those are written interrogatories, and the process is called discovery. So you would file those, and they would have 30 days to respond in writing to whatever questions that you filed during the discovery process. But like I said, you can engage in the discovery process to get more information and documentation prior to a fair hearing if you so choose. And if you need more time to prepare for your fair hearing, you can request a continuance from the hearing officer via email, but you need to be sure to copy opposing counsel. So it's pretty common in Medicaid fair hearings that continuances may be needed in order to make sure, for one example, if you have a doctor that you want to testify and the hearing officer sets, you request a fair hearing and the hearing officer sends a scheduling order for a date that your doctor isn't available. Okay, well, you need to have your doctor testify, right? And so you're going to request you need to request a continuance to make sure that the hearing is set on a date that your doctor can attend and testify in the fair hearing. So that's just one example that you may be requesting a continuance of the scheduled hearing date. And when you request a continuance of the scheduled hearing date, you usually have to email or confer with opposing counsel, with the respondent, prior to requesting a continuance from the hearing officer. So you would just, in those circumstances, send an email to, if it's APD, whichever attorney for APD has been assigned to represent the agency, you would send them an email and say, for example, I need to request a continuance because this is scheduled on a date that my doctor is unavailable and I intend to call him as a witness. And you would ask the respondent's counsel whether or not they have any objection. Once you receive an email back from the agency's counsel in this circumstance, they would say either I object to the request for a continuance, or most of the time I don't object to the continuance. Once you've conferred with them, then you can send the request to the hearing officer via the email addresses that I shared earlier. And you can put the hearing number that you've been assigned, the fair hearing number you've been assigned, in the subject line and put request for continuance. And then in the body, you can write, I need to request a continuance because this hearing is scheduled on a date that my doctor is not available to testify. And then you would put another paragraph. I conferred with respondent or the agency's counsel to see if they had any objection to this continuance, and they either did or didn't have an objection. At that point, once you send that, you've requested the continuance, and usually if it's more than a week in advance, you'll receive an email back, and the hearing officer will either grant or deny the continuance. You do have to copy respondent's counsel on any emails that you send the hearing officer. And when the hearing officer responds back, likewise, they will copy both parties as well. So if you request a continuance, either an emergency continuance or in a short time frame, like there's only 3 days before your hearing and you're requesting a continuance, in those circumstances, it may be that you still have to show up for the hearing because the hearing officer isn't gonna, the hearing officer may opt not to send an email back, either granting or denying it. He or she may make everybody show up to the scheduled fair hearing. And then before anything would get started, they would deal with the motion to continue and either grant or deny it. They would talk probably about rescheduling. But so if it's a short turnaround or a short time frame before that you're requesting the continuance and before the hearing date, it is possible that you would still have to show up. So motion for continuance, a little bit more. A continuance is what a hearing office may grant to delay the proceedings until a later date, like we talked about. And you have to communicate with the respondent's representative prior to requesting the continuance from the hearing officer to ask if they have any objection, whether they agree or disagree with your request for the continuance and your grounds for requesting the continuance. And then, like I said, when you request the continuance from the hearing officer via email, you do have to state that you spoke with the respondent's counsel and whether or not they agreed or disagreed with your request for the continuance. Excuse me. And then, like I said, the hearing officer will either grant or deny it. If they grant it, usually they will just send a quick email to both parties and say, I'm granting the continuance that's been requested, and I'll send out a new scheduling. So at that point, you would just be waiting to receive a new scheduling order with a new date. Usually the call-in instructions are the same if it's telephonic. So that wouldn't change, but most of the time you will have to receive that in the mail, the new schedule. So presenting your case, and this is the first of 2 slides on presenting your case. So all witnesses will be sworn in prior to the fair hearing commencing. So everybody will get on the line, on the recorded line, everybody will call in. The hearing officer will take everybody's name, make sure they have everything spelled correctly. And then anybody that is going to testify in the fair hearing will, the hearing officer will ask them to raise their right hand, and they will all, he'll give the oath, and ask everybody to agree, and that they'll tell the whole truth. And that's kind of what happens on the recorded line, and that's what happens prior to anything getting started. So that's very first. Then both parties will give opening statements summarizing their view of the case, the case facts and issues before the hearing officer. So usually whoever's burden of proof, whoever is going to have to prove their case, they will go first. So if it is for example, service that has been reduced, so you were already receiving, example, 50 hours of personal care service hours, and you asked to continue the 50 hours, and you received a decision reducing those hours to 25. So in this case, they were previously approved services. It's the agency's burden of proof. They will go first. So they'll give an opening statement in that circumstance, then you'll give an opening statement, and you'll kind of summarize just a brief overview of the issues and the facts that are before the hearing officer and how you want them to decide. Each side will be able to call witnesses, elicit testimony, offer documents into evidence, and cross-examine the other party's witnesses. And the hearing officer will also get a chance to ask any additional questions of witnesses they may feel are needed for clarification of the issues. So again, this follows that same pattern. So just like the opening statements, if whoever has the burden of proof will present their case in what's called their case in chief first. So if it's the agency's burden of proof, they're going to call their witnesses first. Now, every time they call, the agency or the managed care company calls a witness, you, as the petitioner or the petitioner's representative, will get an opportunity to ask additional questions once the respondent, the agency, or the managed care company has completed all of their questions for that witness. And that is called cross-examination. Then, once the agency or the managed care plan has called all of their witnesses, and you've had a chance to cross-examine all of their witnesses, they will rest their case in chief, and you will open your case in chief. So you'll be able to then call any witnesses you want to call that help prove your case. And again, the agency or the managed care plan will have a chance once you've finished all of your questioning with each witness to cross-examine it. As far as the documents, the evidence, that can be handled differently from hearing officer to hearing officer. Sometimes some hearing officers will allow all of the documents or the evidence to be offered into evidence at the beginning of a hearing, all as one composite or one composite. And some want each piece of evidence or each exhibit to be entered into evidence one by one. I prefer, even though it's a little bit more tedious and a little bit more work, to offer them one by one. I think it's more effective to offer them one by one, because when you're doing that, you're eliciting testimony that goes with those documents. You're asking questions of witnesses that relate to those documents as you're offering them into evidence. So you know that you're getting all of the really pertinent facts on the record. So presenting your case, this is the second of 2 slides on presenting your case. You should plan your arguments prior to the fair hearing and start by calling witnesses that will bolster your strongest arguments. Make sure all the evidence you want the hearing officer to consider is properly offered and accepted into evidence at the fair hearing. So like I just said, usually at the beginning of a fair hearing, I will ask the hearing officer whether or not they would prefer all of the exhibits or evidence be offered as a composite at one time, or whether they want them to be offered, whether they want me to enter them into evidence one by one. And once you know what the hearing officer's preference is, you just kind of want to honor that as you go through the fair hearing. And the hearing officer will guide the process. So, they don't expect people that aren't represented by attorneys to be experts on the fair hearing process. They will kind of help you along and guide you along as far as the procedure of the fair hearing. So lean into that because they don't expect you to be experts. It's okay to ask for a break to collect your thoughts or slow down if you elicit testimony you weren't prepared for. So you can ask the hearing officer at any time, say, I really need to take a break. Normally, the hearing officer will allow whatever question is being asked, if it's in the middle of a question or if it's in the middle of a line of questions, for that to be finished before a break is taken. But they're usually very open to allowing breaks. And don't ever feel like you need to rush. If you need to just, okay, I just heard something that I wasn't expecting. Just take a moment. It's okay to take a moment and collect your thoughts and then proceed. And when the respondent is presenting their case, you may use objections and state them clearly on the record. And objections are to preserve certain issues for appeal. So the only time that objections are really are pertinent is if you get an unfavorable final order from the fair hearing process and you want to appeal it up to state court. At that point, you may rely on some of the objections that you made in the fair hearing to bring issues back on appeal. But don't let the objections stress you out. Just research the most used ones prior to the fair hearing so that you're able to use them if needed. I would not stress out about objections at all. Even some of the attorneys that are representing people in fair hearings don't use objections very often. So the ones that are, most common are relevance. So if you asked a line of questions of a witness and your scope was limited to what you asked that one witness, and then the agency on cross wants to ask them questions about something way out in left field, then you could object to the question, objection relevance, objection beyond the scope of direct. Because the respondent's questions should be limited to, the scope should be limited to what you asked on direct examination when they're on cross. So that's an example of one that is more commonly used, but don't let them stress you out. It's not going to be the end all be all if you don't know how to use the objections. It's fine. So let's talk a little bit about the procedure of the fair hearings and what to expect. Like I said earlier, the hearing will usually be telephonic. It will be telephonic for the Office of Fair Hearings, and it can be telephonic or in person if you request it for the Office of Appeal Hearings. The people that are present are the hearing officer, the petitioner or their representative. So if they have an advocate, a guardian, a attorney, that's they will be present with the petitioner, the agency area staff, and the agency attorney. If it's the agency that's the respondent will be present. If it's a managed care company or EQ Health, they will have outside counsel. So the outside counsel will also be present. And then any of the witnesses that either the petitioner or the respondent are going to bring will also be present. Approach the hearing and your arguments from a logical and rational standpoint. As much as you can, you want to try to leave emotions out of your arguments. You want to elicit the facts that are essential to prove your case and leave it at that. Again, let the hearing officer guide the proceedings, but don't be afraid to speak up. We talked a little bit about this earlier, but requesting accommodations. You can contact the Office of Appeal Hearings or the Office of Fair Hearings by phone or email to request an accommodation for your hearing. And you should make it as early as you should make the request as early as possible, but usually at least 7 days prior to the hearing date, just so that there's enough time for them to coordinate and make sure that the accommodations that you need are available for the scheduled hearing date and time. I think this may be, well, let me finish this slide, Maddie, and then we can take another break for questions if there are some. So what happens next? So once both sides have rested their case in chiefs, both of their called their witnesses and cross-examined, and the hearing officer has had a chance to ask any additional questions that may have been sparked on direct and cross-examination. Then both sides will give closing statements. So just like the opening statements where you gave a summary of the facts and the issues and how you wanted the hearing officer to decide the case, on closing arguments, you're going to give a summary of all the testimony that's been taken during the fair hearing and kind of a recap and a last plea for the hearing officer to rule in your favor and why they should rule in your favor. The hearing officer may allow for proposed final orders to be submitted in writing prior to their final determination. However, that's not always the case. Sometimes it is just the closing statements or closing arguments, and then the hearing officer takes everything that's been, well, the testimony and evidence that's been collected under consideration, and then they issue a final written order. So after a few weeks, whether you were allowed to, given time to submit proposed final orders, or you just gave the closing statements at the scheduled fair hearing date, it will take the hearing officer a few weeks to go back through all of the evidence, go back through all the testimony, write their final order, and issue it. Once they issue the final order, You're going to read the final order carefully and determine what has been affirmed or what has been denied. So in the final order, the hearing officer will give his findings of fact and his or her findings of fact, and that will be the basis for the final determination that they make on the services, whether or not the agency's reduction should be upheld or whether it should be overturned. So again, you won't get a decision on the day of the hearing. However, if you asked for your services to remain, if they were already a service that was previously authorized, and you asked them to continue pending the outcome of the fair hearing, those services should remain in place until the hearing officer has issued that final order. And in the final order, along with the findings of fact that I just talked about, the hearing officer will also lay out the conclusions of law, which will be the relevant rules, statutes, if there's a handbook that was relevant, that they use to interpret the issue in the fair hearing. So for example, if you're requesting personal supports, you could quote portions of the personal supports description in the handbook and say where in your testimony and evidence this was proven during the hearing, if you're allowed to write proposed final orders. And there's no exact time for a final order to be issued. Usually it takes anywhere from about 4 to 6 weeks is typical. It really depends on how busy the hearing officer's schedule is, you know, how many cases that they have before them, how many final orders that they're working on, how much evidence was taken in the case. So, I mean, if your if your fair hearing lasted several days, that's several days of testimony that the hearing officer has to go back through and consider before writing their final order. That's definitely going to take longer than if you had a 2 or 3 hour final, fair hearing that the hearing officer just has to go back and listen to, a few hours, and then they're able to write their final order. So it just really depends on a lot of different circumstances, but usually between 4 and 6 weeks. And I think before we go on to the appeals, let's take a break and see if there's any questions about this part of the presentation, Maddie.
Great, this is Maddie speaking. First, I want to note that there's some like personal and individual questions in our chat and in our Q&A. And for folks who need specific help or have specific questions, for privacy reasons, we don't want to share everybody's, personal stories and personal situations through a recorded webinar. And we invite you to fill out our online intake that we've provided in the webinar chat, so that you are able to get the assistance that you need. But one question that we want to uplift is that one individual is concerned that they may not meet all the requirements for a previously approved service, but their family member still needs the care from that service, which is now being terminated by the agency. Should they still request a fair hearing if I think I don't have a strong case?
So if it's really fact specific, there's a couple of things that you can do if you don't think you have a terribly strong case. So you need to, depending on what service it is, if there is a lower level of service that might be more appropriate, that may be something that you want to consider as an alternative to the services that were previously issued that have now been either reduced or denied. So it's really taking a look at what are the specific needs of an individual, what is medically necessary, and if you feel like the services are something that need to remain in place, then yes, you should request a fair hearing. If you feel like maybe there's another service that is more appropriate or more or is medically necessary, then you can put in a new service request for that other service. And if the agency or the managed care plan then denies that request, then you would have fair hearing rights on that as well. I don't know if that answers the question, but that's kind of how it works. And you can choose to go ahead with a fair hearing. It's not necessarily going to be prejudicial in the fact that at any time someone's needs could change. So if you receive an unfavorable final, if you choose to go through the fair hearing process and you receive an unfavorable final order, that's not to say even tomorrow that's, petitioner's needs don't change and that now you're requesting, additional services again.
Thank you. Another question that someone had as you were talking about continuances, is there a limit to how many you can request? Say, for example, if you request one, but then realize an important, doctor or person that would be a good advocate in your case is no longer available for that rescheduled date?
No, there's not necessarily a max for requesting continuances. However, at some point the hearing officer is going to want the fair hearing process to move forward. So as best as you can, trying to determine early on who those essential witnesses are and confer with them about their availability is something that you always you want to do. You want to be proactive in. However, things come up all the time, and if you need to request a continuance, there's no max. Should new evidence or new doctor become necessary to call, then yes, you can request it. You can request additional continuances, and as long as you have a good faith reason, a good faith basis for requesting the continuance, usually there's really no pushback from the usually the respondent or the hearing officer.
Thank you. Another question is, during an Office of Fair Hearing appeal of an EQ Health decision, I was told that I could not call the EQ Health caseworker as a witness. Is this accurate, and are there any limitations on the witnesses you can call?
So you can not necessarily. So if EQ Health called the caseworker in their case in chief, then you can cross-examine them. And usually if you're going to ask questions beyond the scope of direct, that is a question that you can usually direct to the hearing officer if you're a pro se litigant. So for example, you wanted to call, you want to ask additional questions beyond the scope of direct to this caseworker that EQ Health has called. You would tell the hearing officer before you started the question, you would say, I either want to be able to call this person back on direct because I have additional questions, or would you just like me to ask all the questions that I have now, even though it's beyond the scope of the questioning, the direct line of questioning that respondent had. And usually the hearing officer will then, like I said, guide the process and tell you what they would prefer to see happen. But no, if there is a witness that the agency or the managed care plan or EQ Health has called, and they're there and they're available, then it's fair game. You can call their witnesses on direct. You can cross-examine them. however the hearing officer really wants to handle that.
Thank you. Another question we have is there any specific advice you have if a parent who is a caregiver daily is being used as a witness? Is there any limitation to that? Can that be done? Or should a separate parent or family member serve as a witness?
So that's really case specific. Certainly if a parent is a daily caregiver, then they're going to have a lot of information and knowledge about the individual's condition. And so that's a personal call. If there's someone else that you feel like you could elicit the same information from, and you would prefer to call that person instead, you can. But there's no bar on a parent or a caregiver, whether they're one and the same, being used as a witness. If they have testimony that would be helpful for the hearing officer in deciding the issue, then they can offer testimony.
Thank you. Another question is, do you have any advice as to how to gather and present evidence when the individual's condition and needs are behavioral? How can a petitioner use behavioral notes as evidence to support the laws, rules, and statutes that should apply?
So again, this is pretty case specific. But yeah, if the services that are at issue, for example, ABA, if that's the service that's been reduced or denied, then you would want to submit evidence like behavior plans, submit evidence like, if they have behavior plans at school, submit evidence of the ABA plans, submit, and you would want those to be as comprehensive as possible regarding the maladaptive behaviors and the interventions that are being used to treat them, and why a certain number of hours are medically necessary. So if it's a behavioral service that's at issue, then yes, you would want to submit all of that. And that could go beyond those. It could go to medical documentation. It could go to pictures. It could go to emergency room records. Really anything that can be used to support the medical necessity of the services that are being requested.
Thank you for that. A couple additional questions are in the Q&A and I'll read them, but if you want to review them as well. If you were to get the final order in the mail, how does an individual know that the outcome was not in favor, and to know if their services were cut before they get that notice in the mail?
So if you asked for your services, if they were previously authorized services that you asked to continue, that they continue to authorize during the fair hearing process, they will continue until a final order is issued. So during that interim time where you're waiting on a hearing officer to make a final determination and issue a final order, those services should remain in place.
Thank you. There's one question in the Q&A, if you would review it, regarding subpoenas. And I personally am not an expert in this field, as y'all who are listening may understand. So I wanted to
It's in the Q&A, Maddie?
yes, it's at the bottom of the open Q&A questions.
Oh, okay. Do subpoenas need to be done for witnesses? And since we aren't attorneys, is there guidance on how this document may look and how to do it? So I would say probably 80% of the time, you're not going to need a subpoena for witnesses. Usually whatever witnesses you're going to call, your doctors or your providers or those are people that the individual with a disability is working with on a ongoing basis. Those are going to be people that you just talk to and say, hey, can you come and will you testify for me on this day at this time? And usually they'll say yes or no. So usually for your own witnesses, you don't need a subpoena. And the only reason that you would need a subpoena is that if you're trying to compel the agency to bring a certain witness that they don't intend to bring to the fair hearing. However, I would say out of 8 out of 10 circumstances, usually just an email to the respondent's attorney saying, I would like you to make this person available for the fair hearing is all you really need. You normally will not have to subpoena them.
Great. And there was a question regarding, emergency Medicaid waivers and the crisis waiver. And we just wanted to uplift that there will be a webinar specific to that topic. And I'm going to drop some information in the chat regarding that. But please note that, yes, there will be a future webinar on this topic, but if you want additional information, you can reach out to our intake unit, or you can visit our website's topic specifically about the crisis waiver. And that will be in the chat in a moment. Angie, would you please take a moment to review the final questions in the Q&A to see if they're something you can answer?
Yes, sir. So I see 2. I see 1, does the iBudget waiver cover special needs children in PPEC? PPEC is a service that is covered by Medicaid. That's not an iBudget waiver service. And if a case was denied by Chapter 59G-1.010, 2.83 Florida Administrative Code, how does one access this code? So you can go to Google and copy and paste that 59G-1.010 FAC, Florida Administrative Code, and it should pull it up. It should pull a link for you to click on, and once you click on it and you get to the page where 59G-1.010 is, there should be a Word document that you can click on that will open the language of that Florida Administrative Code rule.
Thanks so much. There's one final question in the webinar chat that says, where can we find the most common objections that might be used during a hearing?
You can just Google them. You can Google Florida, commonly used Florida objections and litigation, and it'll probably bring a page up. You can Google Florida civil procedure objections, and that should bring it up.
Thanks so much. There's no questions at this time.
Okay, so I just have a couple of slides left regarding the appeal process. So let's finish that up. So once you get a final order, if it's an unfavorable final order, you have the right to request an appeal, and it must be filed within 30 days of the final order. So the final order will have obviously the hearing officer's signature, and it will have a date. And an appeal has to be filed within 30 days of the date on that final order. You may file it in either the District Court of Appeals where respondent is located, which is the 1st District in Tallahassee, or the district that you reside in. Appeals must be based on legal or factual errors in the final order. that, if corrected, would impact the decision made. You can only appeal issues raised during the hearing. So just a few more things about this before we move on. The appeal, if you're going to appeal something to a state court, there has to be a legal or factual reason or error contained in the final order that the hearing officer wrote, that if he or she had gotten it right in the final order, would have changed the decision. So if it was an unfavorable final order and they misstated facts or didn't rely on good law or good case law, then you can take that and appeal it and say, if they had used the right facts or they had used the right law, then this would have been a different decision. And only those kinds of issues are things that you can take up to a state court. And you can only appeal issues that were raised during the hearing. So if it wasn't an issue that was talked about or testimony was elicited on during the administrative fair hearing, then you can't appeal that to state court. And as far as appealing a final order, you really want to go to the clerk of courts. They're super, super valuable. You can go to their website. You can go to the first district's district court of appeal, and it will give you the clerk's phone number and how to reach them, and they will be helpful in helping you get that appeal started if you so wish. But just as a caveat, you need to remember that administrative hearings, so the fair hearing process, are meant to accommodate non-lawyers, but you will have to have an attorney to appeal any of the factual or legal errors in a final order up in state court. So the key is good preparation and organization in the fair hearing process. And just focusing on the issues that are before the hearing officer and making sure that you elicit the most crucial testimony and provide the most crucial evidence that are going to help you get a favorable decision from the hearing officer in the fair hearing process. And that is the conclusion of this presentation. If you have questions or you have specific circumstances that you would like Disability Rights Florida to review or assist with, you can contact us at 2473 Care Drive, Suite 200 in Tallahassee, Florida, 32308. You can contact us via phone at 800-342-0823 or through 800-346-4127. And you can go to our website, like Maddie said earlier, disabilityrightsflorida.org, to fill out an online intake form if that is the easiest way for you to contact us. And then Maddie, do I send it back to you for this slide?
Sure. Thank you so much, Angela. You're getting a lot of thanks in the chat as well. For those who are, still on the call, we really invite you to take our survey, which you can do at bit.ly/DRF_training. Or if you have a smartphone, you can scan the QR code on your screen and it will pop up the survey on your phone. We've also provided it in the chat, so you can click the link in the chat and use the presentation code ZW1 to take a survey about this presentation. We really encourage you to tell us how we did, and your feedback and your comments help us build out better presentations and provide better services to you. So we'd really appreciate it if you could take that survey. It is 11:38. I didn't know if I don't see any questions in the chat or in the Q&A. But if we wanted to pause just in case some folks have questions, if not, we can close out the webinar. Up to you, Angela.
Yeah, we can give it just a minute or two. And if not, then I really appreciate everybody that showed up today. And if you have additional questions, definitely reach out to us through our online intake form, and definitely be looking for our website for all of the materials from today and for those webinars that are going to be coming up as well.